All right, ma'am, your Trinity Bell.
Yes.
And this is cause number 25 DCCR 1381. I'm going to reset, just a normal reset to give you guys time to get it filed down in misdemeanor court, get that taken care of. If everything gets taken care of and you go to court down there, then you probably won't have to come back to this court date. Your case will be dismissed. Unless you hear otherwise, though, plan on being back here unless Ms. Holmes or your bondsman tells you you don't have to, okay?
Yes.
All right,
And
thank
we
you.
had one, Ms. Bell has been wearing a GPS ankle monitor for quite some time, and we were wondering if the court would allow her to have it removed or.
Let me look real quick. I don't know that I have any notes on any issues.
Is your prosecutor down?
Mr. Smith?
Judge, we're not opposed to it.
All right, so Ms. Bell, I'm going to remove that condition of your bond that you have to have. Well, actually, let me make sure first that it's a condition of the bond and not the bondsman.
Oh.
Because if it's their condition, that's up to them. If it was the court's condition, I can change it. And I forget to look at that sometimes and they get very mad at me.
Indifferent is fine.
Let's see if I can figure this out.
What we would do is probably just get a post on those and then just use this. I mean, they don't really do it, since that much, we can just ask for a poster. It's a short and sweet person, that's it. Yeah, letter.
I don't see that I don't see it notated on the magistrate's warnings.
Price to the judge.
Yeah. Okay,
Yeah. Still.
there we go. Right there where it says bonds.
It is.
It's there, it's mine. It's a court bond. Okay, so then our court condition. Have you been going to did you go get an assessment? Have you been going to Spindletop like you were supposed to?
No, ma'am, I lost my job, so I don't have any insurance anymore.
Well, that's the nice thing about Spindletop is you don't have to have it.
Okay. Well, I did make an appointment for it.
Okay, so that was also a condition of your bond
Okay.
that was set. And so it's very important that you still follow through with that. So even if it's going to be misdemeanor case, you need to go get that assessment done, call and make your appointment so that you can get that done before we take care of that other stuff, okay?
Okay.
But I will remove the GPS monitoring device condition today. Ms. Holmes can tell you, y'all can talk about how to do the Spindletop thing, but I'll remove the bond condition of the GPS device today. All
Okay.
right?
Okay,
Okay,
thank
stay in
you.
touch with Ms. Holmes.
Yes.
Daniel Eli, Ms. Holmes?
Your Honor, may I approach on that?
Uh-huh, sure.
That's why I'm here. I came to talk to Ms. Holmes. We should be able, it's gonna be depending upon what happens down the hall.
All right, Mr. Hayward, in cause number 25 DCCR 1346, the state has elected to proceed on the lesser included offense of a Class A misdemeanor, attempted burglary of a building from August 29th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand if I follow the agreement that you've reached with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred probation. There would not be a fine, but there would be restitution in the amount of $2,620. Is that your understanding? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Hayward's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to follow all of the rules and conditions of probation, and you're ordered to pay that restitution in the amount of $2,620. If you do everything that you're supposed to on this probation, get the restitution paid off, this is a great opportunity because you don't have a conviction on your record. And if you satisfactorily complete the probation, at the end, the case gets dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of your probation, then you can be brought back into court, found guilty of the offense, and go to the Jefferson County Jail for up to 1 year. Do you understand? So $2,600 is a lot to pay in 2 years. How old are you? 8. So you're very young. It's very important that you make payments on that every single month, even if it's a little bit, because it'll add up. All right. So some people think, well, I'm going to get a better job, or I'll sell this, or I'll get my tax refund and I'm going to wait to pay it. And then all of a sudden you're at the end of your probation and you haven't paid it. If you come back at the end of your probation, you can have done everything else right and not paid that money. And if I find that you could have paid it, then you could still be revoked and go to jail even after 2 years. Do you understand?
Yes, ma'am.
Also want at least half of whatever he pays to go to restitution in the beginning. Okay. So that way I want them to get paid, the victim to get their money and get paid for what happened. Okay. That's very important to me. So I'm going to hand you now the trial court certification that shows this was an agreement that I followed. And so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation is sitting at that desk right there. She's going to call you up to her desk when she's ready to go over your paperwork. All right. Good luck to you, sir. Thank you.
And I'm going to try to get that squared away. I'm not on all those cases down there, but I'm going to take it just to move this forward.
Are you on this case?
No.
Brittany is.
Yeah, but we can, all that will be squared away.
Well, if he has a warrant today, we've got to.
Yes, he does.
Yeah, it's,
Daniel Eli.
I think he's outside.
I didn't know that either.
I didn't know that part.
Yeah, it's,
Didn't have to do it.
yeah, it has to do with this.
It doesn't. I mean, I just have to do, I mean, if he has a warrant, he's gonna have to go into custody here. And if y'all have a court date down there that y'all can take care of it today, then you can ask the bailiff down there to come get him before they take him to the jail. But I don't have to respond.
Yeah, it's on this part.
It's out large without proper bond on your case, Judge.
Yeah,
For what though?
I don't know, I just got that this morning.
Hold on. So where is he?
He was outside.
Well, it's not anymore.
Maybe did it.
If we,
So Johnny sent a message over. They hadn't, I had an email from May 5th that they had not been able to track him since April 27th, and he will not charge his GPS monitoring device.
I got that email and I called him and he was saying he was having issues with it. So I said, well, go to Johnny's and get it figured out. So I told him to go there. I don't know if he,
Well, I raised his bond because of that.
oh,
that's probably not this.
okay.
I don't know.
Because I do remember seeing that.
But if
email.
I've already raised his bond, then it's not, is it a forfeit? Okay, all right. So he already has a warrant. His bond here is now $150,000 because of that.
Can I go get him?
You know where I mean, she just called his name. If he's here, yeah, go get him. He needs to come in.
I'll go get him.
Thank you. I'll hold it.
Okay.
Are you Secretary Brown? And Mr. Brown, this is your initial appearance and cause number 26 DCCR 0607. You're charged with the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from September 21st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, it is. I didn't know I had to hire one.
So what I'm going to do, once you make bond, I'm going to give you some time and expect you to try to hire a lawyer.
Okay.
So I'm going to reset your case for about 30 days to give you some time to try to hire someone.
Yes.
If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what you need to do.
Yes, ma'am.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. You need to bring me the names of the lawyers that you've talked to when you come back, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back.
This is where the courtroom energy changes completely. Up until now, these sounded like normal felony appearances. But the moment prior convictions enter the picture, everything escalates fast. Judge Raquel is explaining one of the harshest realities in the criminal justice system: repeat felony enhancements. Think about this carefully. The current charge alone may not sound like a life sentence case. But because of prior felony convictions, the punishment range explodes to potentially 25 years to life. That's the part many viewers find shocking. The law doesn't just punish the newest crime, it heavily punishes the criminal history attached to it. And you can tell the defendant almost brushes it off at first, saying he already did his time. But legally, prior convictions never just disappear when enhancement statutes apply. That's why the judge keeps repeating the importance of hiring a lawyer immediately. Would you have realized the stakes were this high if the judge hadn't explained it directly in court? Let me know in the comments, because this is exactly the kind of thing that catches many defendants off guard.
And you would go back to jail. Do you understand? And I'm looking at your indictment. It looks like you do have 2 sequenced felony priors, which means this is obviously a whole lot more serious than just that evading. You would be considered a habitual offender.
Some more priors.
Yeah, looks like you've got 2 priors from September 16th of 2015 for burglary of a habitation. And then after that, an unlawful possession of a firearm by a felon in May of 2020 from Dallas County, Texas.
Oh, yeah, it is. But I'm done with that. I did prison time for this.
I understand, but what I'm telling you is, because you have felony convictions, if you're found guilty on this one, it makes it a whole lot serious.
Okay.
It means that you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or life. So you need to get a lawyer hired before that next court date. Step in front of the clerk. She'll give you a reset notice. Good morning. Are you Richard Montalvo?
Yes, ma'am.
And Mr. Montalvo, this is your initial appearance in cause number 26 DCCR 0448. You're charged with the state jail felony offense of fraudulent use or possession of identifying information. And that's from June 13th of 2025. And since you've made bond, did you have you had an opportunity to try to hire a lawyer?
No,
So what I'm going to do, Mr. Montalvo, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
yes, ma'am.
If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to, so I know you're trying, and we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. You would go back to jail. Do you understand? Step in front of the clerk. She'll give you a reset notice. Good morning, ma'am. Are you Evelyn Odom?
Yes, ma'am.
And Miss Odom, this is your initial appearance in cause number 26 DCCR 0403. You're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from February 8th of 2026. Since you've made bond, have you had an opportunity to try to hire a lawyer?
Spoke to him, I haven't heard him yet, but I did speak to him, right, and I'm probably just gonna know, like.
Okay, so what I'm going to do is reset your case for about 30 days to give you some time to either hire him or someone else. If you do get them hired, whoever, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, different payment plans. Bring me back the names of the lawyers you've talked to, so I know you're trying, and we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? Yes, ma'am.
Just listening. So if this is felony 60, because you just tell the guy he's like getting 25 to life, but it's 3rd felony. Well, this isn't 3rd felony. That isn't. It was 16 years ago and 14 years before that.
It doesn't matter. If this is your 3rd, then that could be a possibility. Yes, ma'am.
Okay.
Yeah. Yours, for some reason, is not listed on your indictment, but that doesn't mean that it's not, doesn't.
Just long as the clerk, maybe. I'm not. I'll talk to the lawyer.
Talk to your lawyer about that for sure. Yes, ma'am. Step in front of the clerk.
Okay, thank you.
Good morning. You're Daryl Albritton. Did you get someone hired?
Well, he went up on his price because the other guys, they had stopped paying them. They paid them the 200. So now he went up to 750. So I'm got 410K. So I gotta go through a verification and take my money out too. Lawyer.
To take your money out of what? I'm sorry.
401K.
Okay.
Because I just found out I had 401K.
So you've been coming here literally for almost a year.
I know, you know, I gotta go back off, so I can't keep coming to court every month.
Yeah, you're gonna come to court every single month until
Yes,
your
ma'am.
case is taken care of, and you're gonna hire a lawyer.
Yes,
If you've got a good job and you're going offshore, then you need to get someone hired. Right?
yes, ma'am.
So I'm gonna reset your case 2 weeks. You need to get someone hired before that 2 weeks, or you need to bring me proof of the paperwork for that you're waiting on some money for 401. Walk in with something that shows me what you're doing. Otherwise, you're gonna end up in jail. You understand?
Yes,
Step in front of the clerk. Morning, are you Nathaniel Campbell Jr.? And Mr. Campbell, this is your initial appearance and cause number 26 DCCR 0424. You're charged with the third-degree felony offense of continuous violence against a family member from February 6th of 2026. Since you've made bond in your case, have you had an opportunity to hire a lawyer? So what I'm going to do is reset your case about 30 days to give you some time to try to hire someone.
Okay.
If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to. So I know you're trying, and we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
30 days.
I'm sorry?
30 days?
Yes, it'll be about 30 days.
Yes, ma'am.
So, as a condition of your bond, you understand that you cannot have any contact or communication at all with Cheryl Campbell. Do you understand?
Well, then she called me when I told her, hang up.
Hang up. Because she's not going to go to jail. You are. Right?
She been calling me about it.
Well, then hang up, because here's the thing. She cannot give you permission to violate my court order. So it's a condition of your bond that you have no contact or communication with her.
37 years, man.
I don't care how long it's been. And I don't care what she tells you. So there's no other discussion
That's
about
what I
it.
mean.
No other discussion. No contact, no communication, or your bond will be raised and you'll go back to jail.
Yes, ma'am.
That's how serious it is. You understand? Okay, step in front of the. Good morning, sir. Are you Casey Kincaid? And Mr. Kincaid, this is your initial appearance and cause number 26 DCCR 0641. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle. And that is from February 6th of 2026. Since you've made bond, have you had an opportunity to try to hire a lawyer? Speak up.
I said no, ma'am, but I will.
Okay, so you're in the same position. I don't know if you were in here before. You've got 2 prior felony offenses that are sequenced. And so this is obviously a whole lot more serious than just that third-degree felony. So I'll reset your case about 30 days to give you some time to try to hire someone. If you get them hired, just bring the reset notice you get to them. They'll tell you what to do. If you're unable to hire someone, you need to visit with at least 3 lawyers. I'm ordering you to do that. They all charge different amounts, different payment plans. Bring me those names so I know who you're talking to. Then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you go back to jail. You understand? All right, step in front of the clerk. Morning, you're Kaya Nash.
Yes, ma'am.
Did you get someone hired, Miss Nash?
No, ma'am, I talked to him, but I lost my job, but it was like 2 pricing.
Who'd you talk to?
Miss Brittany Holmes, Jason Dix, and Mr. Ralph Campbell.
Okay, well, thank you for doing what I asked you to do, Miss Nash. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to make sure and fill it out accurately and completely, because you're going to swear under oath that it's all true and correct, and then I'll take a look at it.
Yes, ma'am.
Step in front of the clerk on the end, and she'll give you that paperwork. Right over here.
What's your first name? I think.
Good morning. Are you Charles Toussaint?
Yes, ma'am.
And Mr. Toussaint, this is your initial appearance and cause number 26 DCCR 0527. You're charged with a third-degree felony offense of unlawful possession of a firearm by a felon from January 23rd of 2026. Since you've made bond in your case, have you had I gave you a medical PR bond, didn't I? So are you working? Are you able to work?
No.
Okay, so what I'm going to do this morning, Mr. Toussaint, is have you fill out some paperwork to see if you qualify for a court-appointed lawyer. You need to make sure you fill it out accurately and completely.
Legally blind.
You're legally blind. So let's just do this. I'll find that you qualify for a court-appointed lawyer. If you'll just come over here in front of the clerk, she's going to let you know who that is and how to get in touch with them. Okay, and then she'll give you a reset for your court date as well. Yes, sir. Good morning. You're Brian Herrera Gonzalez.
Yes, ma'am.
Mr. Gonzalez, did you get someone hired?
Yes, ma'am. I heard Benjamin Jeffers.
Okay, is he supposed to be here this morning?
Yes, well, he sent you. I think he sent something to them. I took email.
When did you hire him?
Late afternoon on Friday.
Okay, it probably hasn't come through yet. I don't see it, but sometimes when they send something on Friday, it doesn't get through the whole system by now. So let's do this. I'm gonna go ahead and have you fill out a reset for about 30 days. Make sure you take that to Mr. Jeffries. And
Okay.
between now and then, he'll probably get a different court date. But unless you get a different court date from him, come on the date that you've got.
Yes, ma'am.
Is there, Ms. Malfino, did you have something?
No, I just wanted to check on something.
Okay.
This is a case that transferred to me from CDC. I believe I've got the co-defendant and now.
Okay,
If I caught the name correctly. I
okay.
just wanted-
Thank you, ma'am. So, did you hear all that? It's just up in front of the clerk. He said he's already hired him, but it was Friday afternoon, so I don't see anything. Let's just do a normal reset. And good morning, sir. Are you Travis Hingston?
Yes.
And Mr. Hingston, this is your initial appearance in cause number 25 DCCR 1180. You're charged with the third-degree felony offense of tampering or fabricating physical evidence from August 28th of 2024.
This hearing was a perfect example of how courtroom decisions are often about much more than the charge itself. Judge Raquel spent this entire session balancing second chances with accountability, removing GPS monitoring for one defendant while warning others they were dangerously close to prison time. We also saw how prior convictions can completely transform a case, turning what seems like a manageable felony into a possible life sentence under habitual offender laws. What stands out most is how direct the judge was with every defendant. Whether it was warning someone about violating probation, explaining no-contact orders, or making it clear that excuses won't stop a bond from being revoked, the message stayed the same. The court expects action, not promises. And honestly, some of these defendants were given opportunities many people never get. The real question is whether they'll take advantage of them before the system runs out of patience completely. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real courtroom drama every week.
24. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Right. So when you're in custody, we automatically give you a court-appointed lawyer. Now that you've bonded out, I expect you to try to hire your own. So what I'm going to do is reset your case about 30 days to give you some time to hire someone. If you get someone hired before that next court date, bring the reset notice and to that lawyer, they'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers you talked to when you come back, so I know you're trying, and then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes.
Okay. And it looks like you also have 2 prior felony convictions on your indictment, which obviously makes this a whole lot more serious. It means you would be considered a habitual offender potentially with a minimum 25 years in prison punishment up to 99 years or life. So it's very important you get someone hired. Are you chewing gum? Please don't chew gum when you come back next time. All right. Step in front of the clerk.